Welcome, everyone. My name is Tony Wilkin-Gibbart. I am Executive Director of Midwest Environmental Advocates, and we are here today to announce that on behalf of a group of environmental and public health advocates, MEA has filed a motion to intervene in a lawsuit initiated by Wisconsin Manufacturers and Commerce against the Wisconsin Department of Natural Resources. WMC's lawsuit seeks to eliminate DNR's authority to regulate per and polyfluoroalkyl substances, which we know as PFAS, under Wisconsin's spills law. And the spills law is the only meaningful protection that the state has to protect Wisconsin communities from PFAS. And in fact, the federal government currently does not have meaningful regulatory protection currently. But what's more is this lawsuit would seriously undermine DNR's ability to protect Wisconsin communities from many other hazardous substances. My organization, Midwest Environmental Advocates, is a public interest law center working for healthy water, land, air, and government. And we represent 4 organizations and 1 individual, all of them longstanding environmental and health advocates who are seeking to participate in this lawsuit to defend their interests and the interests of their members. The 5 parties that MEA represents are the Wisconsin Environmental Health Network, River Alliance of Wisconsin, Clean Water Action Council of Northeast Wisconsin, Citizens for a Clean Wausau, and Doug Oitzinger, who is a resident of Marinette and a former mayor of that city. Each of our clients will be directly impacted by the outcome of this case, as will many other Wisconsinites. We'll hear from representatives from each of these organizations that are seeking to intervene, and then there'll be an opportunity for questions. And I'd ask members of the media to put your question in the question and answer feature of the Zoom webinar here. And please also include your name and affiliation. We'll only have time to address questions from members of the media today. So to get started, we'll hear from Dr. Beth Miri, who is co-president of the Wisconsin Environmental Health Network. Dr. Miri?
Thank you, Tony. As a pediatrician, I care deeply about the health of all people, but especially of our children. After practicing general pediatrics in Madison for over 15 years, I am now dedicating myself to advocating for environmental issues related to children's health. And as Tony mentioned, I am the co-president of the Wisconsin Environmental Health Network. I'm also a member of the Council of Environmental Health of the American Academy of Pediatrics. Our group, Wisconsin Environmental Health Network, aka WEN, is a group of health professionals, and we seek to inform other health professionals, the public, and policymakers about the effects of environmental toxins and climate change on public health. WEN has played a critical role in securing and defending environmental regulations that protect human health. WEN's request to intervene in this case is about defending the legal protections that keep Wisconsin families safe and healthy. Over the years, I have given presentations and testified numerous times before the Wisconsin legislature on the negative health effects of exposure to toxic substances, anything from lead to PFAS and more. As a health professional, I have become increasingly concerned about the health effects of PFAS. These chemicals are extremely dangerous. Some call it the PCB of our day. They're highly persistent in the environment. They bioaccumulate in humans, meaning they stay in the body for long periods of time, and there's no effective way to remove them. Exposure to PFAS, even at low levels, has been linked to serious health problems, including increased risk for certain cancers, reproductive and developmental problems, thyroid hormone disruption, elevated cholesterol, ulcerative colitis, and negative impacts to the immune system, including decreased response to vaccines. WMC's lawsuit would potentially remove the only meaningful public health protection that we have to address PFAS and other toxic chemicals, the spills law. Wisconsin's spills law plays an important part in protecting the public from exposure not only to PFAS, but to thousands of hazardous substances, from industrial pollutants to manure to agrochemicals, and the list goes on. A ruling in this case that favors WMC and undermines the spills law would have devastating consequences for the health of Wisconsinites. We simply cannot allow that to happen.
Thank you, Dr. Miri, and thank you for Len's participation in this matter. Next, we'll go to Allison Werner, Executive Director of River Alliance of Wisconsin.
Thank you, Tony. I currently serve as the Executive Director of the River Alliance of Wisconsin, a statewide nonprofit organization that has been empowering people to protect and restore water for more than 25 years. River Alliance has members of more than 1,500 individuals, businesses, and local watershed groups. Have made significant investments in advocating for the cleanup of Wisconsin's waterways. If WMC prevails in dismantling the spills law, efforts to clean up those waterways will be reversed by unregulated pollution. Preserving the integrity of the spills law is crucial to DNR's ability to protect Wisconsin's rivers and lakes. WMC's assault on the spills law is a significant threat to Wisconsin's water resources, to public health, and to all the sectors of our economy, including tourism and agriculture that rely on clean water. The outcome of this lawsuit will also affect me personally. I live in Madison, and my home is only 2 blocks away from Starkweather Creek, which is contaminated with harmful levels of PFAS. That means my family and I no longer feel safe fishing or swim or recreating in the creek, activities that we enjoy. The DNR is overseeing remediation efforts to remove PFAS from Starkweather Creek. And if they are successful, my family will feel safer using the creek again. However, if the plaintiffs prevail in this lawsuit, the DNR will lose the authority it requires to help my family and thousands of others in Wisconsin who are impacted by contaminated water and soil.
Thank you so much, Allison. Next, we'll go to Dean Hoager of Clean Water Action Council of Northeast Wisconsin. Dean had some technical difficulties, and so his video likely will not appear. But Dean, are you able to address us now? We're going to give Dean 1 second here. Dean, if you're able to join us in a moment, we'll come back to you. But Tom Killian, Citizens for Clean Wausau, could you go next, please?
Thank you, Tony. My name is Tom Killian. I'm a founding member of Citizens for a Clean Wausau. CCW is an association of volunteers formed to monitor the activities and impacts of current and past polluters. We believe that citizens have the right to access important information about the environment in which they live, and that it's the government's duty to enforce environmental laws in order to protect all residents. It's important to point out that the outcome of this case could have implications for virtually every community in the state, not just those facing PFAS contamination. The city of Wausau and its citizens are directly impacted by the DNR's ability to regulate hazardous contamination under the spills law. Right now, there are 24 open sites within the Wausau city limits listed on BERTS, the DNR database. There are also 520 closed sites listed. Many of those have elevated levels of residual contamination, and the responsible parties have continuing obligations overseen by the DNR. The spills law has enabled us here to address industrial contamination that impacts residential areas, public parks, and the Wisconsin River. For example, CCW's research on waste burning triggered the DNR to request an aerial deposition study from Waleco. And that study's soil sampling and analysis ultimately led to a responsible party letter being issued by regulators to the city of Wausau for dioxin contamination in a neighborhood rail corridor, part of an open ERP site that now includes substantial dioxin soil contamination in the neighborhood park, Riverside Park. And CCW's members' research and contributions also played a significant role in the additional environmental investigations by the city of Wausau of 1300 Cleveland Avenue, part of the former Connor Forest Industries property. And these investigations eventually culminated in another DNR responsible party letter and ERP site listing for soil contamination related to thallium, arsenic, and PAHs. CCW's watchdog activities and associated video recordings also triggered a DNR investigation into an improper discharge into the Wisconsin River during a major road construction project on Thomas Street that resulted in a fine for a contractor. Its research on contaminant concentrations from the outfalls of the local wastewater plant, reported on by local media, ultimately led to government testing that confirmed pentachlorophenol contamination in numerous neighborhood manholes of the sanitary sewer. In short, without the spills law, we'd have no legal recourse for holding polluters accountable. Regular folks would be forced to figure out how to deal with soil and water contamination on their own.
Thank you so much, Tom. Thank you for Citizens for a Clean Wausau. I know that you have advocated tirelessly, invoking the spills law to protect the health of your community in Wausau. And it's an honor to work alongside you. I see that Dean has come off of mute. Dean, are you able to address us now?
Yes, I am, Tony. Thank you. I currently serve as President and Executive Director of Clean Water Action Council of Northeast Wisconsin. The mission of Clean Water Action Council is to promote a safe, healthy, and sustainable environment in Northeast Wisconsin, to educate and inform the members, our members of, and members of the public on environmental issues, and also to take action on behalf of members and the public to protect the environment and human health. Clean Water Action Council has members who live in and whose families and friends live in the Marinette and Peshtigo communities that have been devastated by PFAS contamination stemming from Tyco Fire Products testing operations. Clean Water Action Council members, excuse me a moment, Clean Water Action Council members also are unable to safely drink their water, their tap water, and eat local fish and game, or fully enjoy their local natural surroundings if they live in Marinette and Peshtigo. The DNR's authority to address PFAS contamination in these communities is entirely dependent on the spills law. The idea that the spills law could be gutted and that we would return to a time when polluters weren't held accountable for cleaning up contaminated soil and water is unthinkable. Unfortunately, that's exactly what's at stake in this lawsuit. Thank you.
Thank you so much, Dean. I also want to let folks know that Doug Oitzinger is a proposed intervener along with the 4 organizations. Doug was not able to join us this morning, but we're putting a video statement that Doug recorded in the chat. And similar to some of the issues that Dean just talked about in Marinette and Peshtigo, Doug, as an alder in Marinette, a former mayor, and a community member where there is ground zero of PFAS contamination from Tyco Johnson Controls. He has been a tireless advocate for his community. He has advocated under the spills law, and DNR has been providing critical assistance to his community to protect their health and safety. Right now, Tyco, under DNR's supervision, is preparing to fund and implement a complex and necessarily costly remediation plan that will run many years. If properly implemented, that plan will and is expected to remove a substantial amount of PFAS from the environment. But as Dean says in his, as Doug says in his statement, if the spills law is rendered inoperable, if DNR loses its authority to address PFAS under the spills law, all of these critical protections go away for his community, and that's why he's participating in the lawsuit. We're about to get to questions. Those are the speakers that we have right now. But before we do, and we have a little bit of time, I want to answer one of the questions that I think, or address one of the questions that many of you might have, which is how this lawsuit would extend beyond PFAS. And that requires just a little bit of explanation. So I'll state it now. Under its fourth claim in its lawsuit, WMC asserts that DNR must promulgate a rule that lists all hazardous substances and the quantities and concentrations that those substances are hazardous in for DNR to have authority over those substances under the spills law. So talking about substances, toxic chemicals other than PFAS compounds. The problem is that rule that WMC is asking for, it doesn't exist. And it doesn't exist because that's not how the spills law has worked. That is not how the legislature that created the spills law over 40 years ago intended it to work. Therefore, if WMC is fully successful in this lawsuit, DNR, at least for a time, would likely be left without legal authority to regulate many hazardous substances. They would lack authority for reporting requirements, ordering investigations, and ordering cleanup, at least until that rule is in place. And those of you who cover state government know that permanent rulemaking can take well over 2 years under the best of circumstances. And thanks to laws that WMC has advocated for over the course of the last decade, it's possible that that rulemaking will never go through. It's subject, one reason is that it's subject to legislative interference. And those of you that cover the PFAS issue will know that WMC objected to emergency rules on a narrow piece of legislation dealing with PFAS and firefighting foam in late 2020. WMC successfully lobbied one legislative committee, the Joint Committee for the Review of Administrative Rules, to strike down parts of the emergency rule that WMC did not like. There is no reason for us to think that WMC would not have countless objections to a rule that needed to address every possible hazardous substance. And that's not all. Under the RAINS Act, any rulemaking that WMC is asking for under this lawsuit may not be possible. Under the RAINS Act, any rulemaking that results in compliance costs over $10 million in a 2-year period cannot be promulgated by as a rule by the agency. If DNR needed to promulgate a rule that lists every hazardous substance in every concentration, that would be a massive piece of regulation. And certainly, it's almost certain that WMC or other special interest groups would argue that the compliance costs are over $10 million, the RAINS Act is triggered, and the rule can't go forward. Therefore, the legislature would need to pass a law authorizing the rule. That effectively means that the legislature would need to reauthorize the Spills Act again, even though no elected official, much less a majority of the legislature, ever voted to repeal the law in the first place. So that's a bit of an explanation about that implication of the lawsuit. But I also want to say that the burden should be on WMC to explain how its lawsuit doesn't seriously undermine environmental health protections in Wisconsin. They should have to explain, if they are fully successful in this lawsuit, what toxic substances they think DNR will still be able to protect us from, and which toxic substances DNR will no longer be able to protect us from. WMC talks about this issue as if it's an issue of regulatory certainty. Well, I think folks have heard here today that this intervention that we are filing is about uncertainty. It is about the terrible uncertainty and danger that WMC is creating by a lawsuit for people in Marinette, Wausau, French Island, and other communities across the state. WMC cannot seek through a lawsuit to break a bedrock, essential public health protection and expect there to be no consequences on the lives and the well-being of the people that that law protects. And that's why we are bringing the voices of these groups and Doug Oitzinger to this legal issue. So thank you all, and we'd be happy to take questions. I'm looking in the chat here. You see the the video link to Doug's statement. And I don't see any questions either in the chat or in the question and answer feature. So if folks are having any trouble with the question and answer window, please feel free to put those in the chat. We'll take them anyway. If there are no questions at this time, we'll give it just a minute, but if there are no questions, oh, we've got a question. What are the next steps and what happens now? That's from the Wausau pilot and review. Thank you so much for being here and thanks for your great coverage. I'm familiar with it. MEA and the potential interveners are filing today. The court also is holding a procedural hearing on motions that WMC and the Department of Justice, the Wisconsin Department of Justice, have filed as a preliminary matter. We expect that once we file our motion, that the court will set a hearing on that motion and it will decide whether the interveners are allowed to participate as full parties. Beyond that, we expect, based on filings in Waukesha County Circuit Court, that the Circuit Court will decide many of the legal issues, or at least begin to decide them at a November 2021 hearing. So regardless of what happens today at the hearing in Waukesha Circuit Court this afternoon, we expect that the main legal issues in this case will still be undecided for many months. And again, our proposed interveners seek to participate to explain the real world severe consequences of this lawsuit. We've got another question from Danielle Kading. Any thoughts too on JFC's recent action to prevent the hiring of additional PFAS positions and funding for communities to address contamination? Well, certainly, we are following that legislative action. I think it also, as it relates to this lawsuit and the implications of this lawsuit, as I explained, there are numerous opportunities if a rulemaking is required for the spills law to be effective in Wisconsin, for the legislature to interfere in that rulemaking process. And Danielle, the recent votes in the Joint Finance Committee that you mentioned are indicative that the majority members of the legislature and of the various committees are not sufficiently prioritizing public health and addressing PFAS in Wisconsin. And so that is part of the reason why the consequences of this lawsuit are so dire, and why so much is at stake in this lawsuit. So I think that's the relation. Would anyone else like to say anything about the JFC votes, Joint Finance Committee votes? Okay. We've got a question from Susan Bent. If WMC is successful, would it mean that Tyco would not be required to proceed with the groundwater extraction and treatment system? Susan, without looking at the orders that DNR has issued with respect to Tyco to answer that question, I don't want to give a definitive answer, but I will say in general, yes, those are the kinds of remediation orders that are absolutely at stake in this lawsuit, and would refer you to Doug Oitzinger's video comment, and I know that he'll be available for interviews over the course of later this afternoon. And he speaks in no uncertain terms about how critical the spills law is for the investigation and remediation that is occurring in and around Tyco Johnson Controls. Danielle asked, follow-up, are you expecting to intervene in WMC's other lawsuit? And Danielle, I'll just answer that question by saying we do not have plans to do so at this time. Our attention is focused today on this action and the, as we've been saying, just the incredible consequences for public health. That doesn't foreclose any other possibilities, but the answer is not at this time. It looks like we may have addressed all the questions. So if there are no other questions, I'll just let participants know that we'll be circulating a press release later today, which will have other resources. And we are also available for any questions here at Midwest Environmental Advocates. And we'd also be happy to direct you to the potential interveners for comment. With maybe Peg or Hannah, if you could just put the contact information in the chat, that way folks will have it. Before we wrap up, is there anything else that anyone else would like to say? Okay. Well, I just want to thank everyone for joining us this morning. And I want to thank the representatives of the potential interveners organizations for their tremendous advocacy and for standing up for environmental health in the state of Wisconsin against this brazen attempt by WMC. And so we'll end it there. Susan, I just saw that you asked a question about the upcoming procedural hearing. So that is this afternoon in Waukesha Circuit Court, Branch 1. It is on the Wisconsin Department of Justice's motion related to WMC's original complaint. It's the first hearing in the case. And if you want to shoot me an email, I'd be happy to send you the information on CCAP and the remote viewing options for that hearing. Great. Thanks, Susan. All right. Well, we will conclude there. Again, thank you all for participating, and please reach out to us at Midwest Environmental Advocates. Peg Schaefer, our Director of Communication, her email is in the chat, pschaefer@midwestadvocates.org. You can also reach out to me, Tony Wilken Gibart, T.Gibart@midwestadvocates.org. All right, thank you very much.